They could demand your bank statements without you knowing it. They could reach into your account and take your money. And while they're waiting for that to happen, they could issue you with a notice to suspend you from driving because they say that you owe them money. This is a bill that not many people are talking about. A few people have asked me about, so here it is. But if this goes through, it could well be one of the most authoritarian, dictatorial hell pieces of legislation that we've ever known. The flip side to that is it would give them quite a lot of power to clamp down on fraud, which is probably a good thing. But those that get caught up wrongfully in what they say is fraud is another matter. Because very briefly, I know firstly from our own perspective, but from lots of people's perspective, they have corrected HMRC on mistakes they've made where they've insisted something was not paid or incorrect or whatever, only to find out it was their mistake. Something as silly as this. We paid a tax bill for the appropriate period. They marked it as being late and threatened us with a fine. So we had to go back through the accountant to say, no, actually, we have paid it on time and this is absolutely correct. They had incorrectly applied it to the previous tax year, assuming that we were paying that one late for some reason because we had paid the previous one. That's how these mistakes can happen. But in that scenario, if they just looked at it as a cursory glance, it would have looked wrong to them for some reason. I don't know why it did, but it looked wrong to them. And that is exactly the point here. People that get caught up incorrectly in this bill are going to pay for it. Now, this is the Public Authorities Fraud, Error and Recovery Bill, which is now at the committee stage in the House of Lords, so it's not quite finished yet. It has a while to go before royal assent and actually becomes law. But let's have a look and see what it is, what it does, and what the problems are with it, in my view, of course. Let's take a look, first of all, of what it's all about. Well, this sets out the core functions in Section 1, core functions of the Minister for the Cabinet Office. And the predominant bits that I'm going to look at in this section are in Section 1, Sub 1 and Sub 2. Those being Sub 1A, Minister for the Cabinet Office has the following functions of investigating suspected fraud against public authorities, recovering amounts mentioned therein, subsection 2, taking enforcement action in connection with fraud against public authorities, and providing support to public authorities in relation to preventing and tackling fraud. And then sub 2, the amounts are as a result of fraud or error. We've had errors before. We did nothing wrong, but there was an error, not our fault. That the ministers identified or confirmed during the course of an investigation in respect of suspected fraud, etc., etc. Sub 2, public authority is entitled to recover, and B, any amount that a public authority is entitled to recover in respect of fraud and interest, and so on. So how do they do all that? How would they know? And what's going on? So just take for a moment that anyone that is, let's say, for example, in receipt of some kind of benefits and there's been some kind of error or some kind of fraud, etc., this is where these sort of things can come in. Now, let's look at Section 3. Now, there's a huge concern, really, regard to privacy here, because bearing in mind this can come about by an error. Section 3 provides that a third party, such as a bank, will give specified information when they consider it's necessary, proportionate to do so, and in any information that relates to a person who they've got reasonable grounds to suspect has committed fraud, etc. And under Section 19, under subsection 2 first, they can require the bank to provide 3 months bank statements immediately before the notice period or a longer period. And that is to happen before they are able to make a direct deduction order in respect of that person's account. Because if we jump to Section 17, a direct deduction order, now ordinarily we have to go to court, make representations, etc., and then even before the order is made, the other person has the opportunity to make representations, etc. For example, a third-party debt order, which I've obtained many times before. Under this section, where a payable amount is recoverable from a liable person who holds an account with the bank, they may make an order, a direct deduction order, in respect of that account. A direct deduction order must be given to the bank and may be regular or a lump sum. A regular direct order is made requiring the bank to make regular deductions, and a lump sum is just to take a whole lump over and pay that over to the minister. But it doesn't end there. It's not just the quote-unquote liable person that might get caught up in this. Under Section 18, accounts which may be subject to a direct deduction order are not just in respect of an account held by that liable person and contains the amount that they say that they have the beneficial interest, but also in respect of a joint account only if the person liable does not hold a sole account in respect of the deduction order may be made, which would likely result in the recovery of the amount paid. So in that scenario, liable person, they say, has a separate account but no money in it, but they also have a joint account with their new partner who has no idea what's going on here. They can then make a direct deduction order in respect of that joint account. That's horrendous, you might say, but it doesn't end there. It gets worse. Let's take a look at Schedule 6, which is quite alarmingly titled Disqualification from Driving. It is as it sounds. This applies where the Secretary of State has sought to recover a recoverable amount from a liable person, and some or all has not yet been recovered, where the amount still to be recovered, which is at least £1,000, so this only applies as long as it's at least £1,000, the state may apply to the court for a suspended disqualification order. A suspended disqualification order is an order where they say that if you still don't comply with the terms set out to repay this money, you'll be suspended from driving. Now, bearing in mind that this applies to fraud and errors, so many of you might think, well, good, let's get hard on those fraudsters. But this sounds very much like guilty until proven innocent. But many of you might say that absolutely cannot possibly true. We are innocent until proven guilty. They can't do any of this until proven guilty. But that's not quite true, because if we go back to Section 3 once more, this says that the information relates to a person whom the minister has reasonable grounds to suspect has committed fraud against the public authority. Not has been found guilty, has been through the whole process, just has reasonable grounds to suspect that they've committed fraud against a public authority. Now, that could vary anything from they have absolute solid material that says that they are guilty to they've got it completely wrong, such as like literally the wrong person. And that's not as ridiculous as you might sound. You know, two people with the same name could live in the same city, for example, and they've just got the wrong person. This happens, believe it or not, all the time in all different areas of life. People have the same name. They are mistaken for being that person. We've had photographs published to say this person did this horrific crime, and obviously they didn't. I've had clients like that, and I've had to go to the company and say, you need to pay compensation here because you've said that this, these are utterly ridiculous things, but it does happen. And bear in mind, if we take a look at Schedule 5, Recovery from Bank Accounts, Section 1 provides where an amount is recoverable from a liable person who holds an account with the bank, they may make an order in respect of that account. And if we take a look at Section 15, a payable amount is a recoverable amount as defined in Section 1(3). 1 sub 3 defines it as a recoverable amount, and the amount under sub 2 is a payment as a result of fraud or error that the minister has identified or confirmed during the course of an investigation in respect of a suspected fraud against a public authority, and the public authority is entitled to recover, or any other amount that they're entitled to recover in respect of fraud and the interest, and so on. If you disagreed with the direct deduction order, you can ask for a review, but you must do that within 28 days under Section 34. Or you can appeal it to a first-tier tribunal under Section 35. And either of those will be necessary unless you agree with the deduction. And this is under Section 12, restriction on availability of those powers. So they can only do this either if you agree or there has been a final determination by a court or tribunal that it is a recoverable amount, which would require you to take that action. So it sort of is guilty until proven innocent. Because if we jump back to Section 35 once more, this is the section on appeals. Bearing in mind 34 is for the review, and then they can just come back and tell you what the outcome of the review is. Or Section 35, you may appeal to a first-tier tribunal against the direct deduction order or to vary it, or against the refusal to vary it. And you may not make an appeal under that section unless you've applied for a review of the decision to make or to vary or not to vary an order, and you've been notified of the outcome of that review. And the timeline for the appeal to the tribunal is 28 days, beginning the day after the day on which you were notified about the outcome of the review. So, in other words, if they make a deduction order and you don't agree with it, you have 28 days to apply for a review. Then they can come back and they could just tell you that they uphold it and it stays as it is. Then you have 28 days, beginning the day after that day, to go to the first tier tribunal to challenge it for a final determination. But if you ignore all of those, then they can just take the money. They can make it a final order and take the money from your account. So let's through some examples, shall we? Let's take a fictitious lady called Sarah, single mother who has a joint bank account with her partner Tom, who unknowingly received £2,000 overpayment in benefits of some sort due to an administrative error on the part of DWP. The Secretary of State will then issue an information notice to the bank demanding 3 months bank statements. That's under Schedule 5. And without notifying either Sarah or Tom about this, they then propose a direct deduction order to recover the £2,000 from their joint account. Remember, Sarah has no idea about this in the first place. But presuming that Tom has a 50% beneficial interest in it of £1,000, the bank then freezes that account, prevents her from paying children's school supplies or paying for her rent and so on, even though she had no involvement in the overpayment, but her funds are now being frozen. And the onus then is upon her within 28 days to apply for the review. And then if that's refused within 28 days of that, of taking it to a first tier tribunal, all of which she might struggle to do without the assistance of legal support. And of course, the funds that have now been frozen by the bank in the meantime. And therefore, in reality, this bill, if it became law, would allow this deduction from a joint account if the liable person, Tom, doesn't have a sole account that they can take money from, and yet he has a beneficial interest in this joint account with Sarah. Paragraph 4 permits this presumed equal share in joint accounts, so non-liable holders like Sarah will get caught up in this. Taking another example, let's call him Phil, a self-employed delivery driver, owes £1,500 in overpaid benefits, again due to an error on the part of DWP, because obviously this is fraud and error, so I'm focusing on the errors because those are most likely to be unfair. He didn't notice it. He had no idea that this happened. They apply for a suspended disqualification order because that amount is outstanding, because the debt then exceeds £1,000. The court issues the order along with a £100 a month repayment plan, but he misses the first payment, or he has a slow month 2 and can't pay the second month payment, so he hasn't caught up with that, hasn't stuck with the plan. They then apply for an immediate suspension, a disqualification order, because remember that was a suspended disqualification order, so they can then apply that this act is activated immediately and suspends him from driving. And then because the court finds no reasonable excuse for not paying it, then they disqualify him from driving for 18 months. Because under Schedule 6, paragraph 2, sub 4, the duration for a disqualification may not be longer than 2 years beginning on the day that the order was made. So they could be banned from driving for up to 2 years whilst they don't comply with the requirements to repay this money that may have been paid to them in error in the first place. So as you can see, this is quite a draconian bill. There's obviously a lot of intricacies here that I haven't covered in full detail. That would take far too long. That is an overview of what this bill is and what it does. Fairly draconian, fairly ethically challenged, I might say, to say the least. There's a lot of things about this that I really don't agree with. I'm sort of hoping that a few things come back from the Lords to change this, but I'll come back and update you as and when that happens. But overall, whilst there are some safeguards in there, such as you can request a review of this order, and if they refuse the review and uphold the order, then you can take it to the tribunal to challenge it, and only then they can take the money. That is a little bit like guilty until proven innocent, even if it's just an error on their part or the suspected fraud on their part, which you could challenge the substantive underlying issues of when you get to that tribunal. But they can take a long time. Whilst the application process is within 28 days of the order, then We don't know how long those reviews are going to take. And in the meantime, the bank is going to freeze the amount in the account, just like they do in a third-party debt order, either for the regular deductions or for a lump sum amount of money. Now, realistically, this is going to be at least for the 28-day period that you would then review it for, but we don't know how long the reviews will take. And then if they uphold the order, then you have to go to a tribunal, and we don't know how long they take either. But notoriously, they can take a long time, and they can be quite difficult to do by yourself. So quite the draconian bill, in my view. But on the flip side, it does give them quite heavy-handed approach to deal with fraud and recover that money, which after all is, if it is fraudulent money that has been defrauding of DWP, of benefits that they shouldn't have had and so on, then that is quite a powerful bill that would be law to allow them to recover those funds, which ultimately are taxpayer funds that should be used on other things. And we should take a strong stance against fraud. I'm just not so keen on the apparent guilty until proven innocent approach. But if it is fraud, maybe it's time to get hard on them. Who knows? There's two ways of looking at this. Let me know what you think about that in the comments below. I think it's quite a harsh bill, but maybe harsh things are needed. And if you've got nothing to worry about, maybe we're okay. But I do know, I say that, I hear you screaming at the screen as I've just said that, because I don't entirely agree with that, by the way. I mean, we as advocates, we say things we don't always agree with. We just give both sides, because I have known some quite serious errors. We're talking a fairly chunky amount of tax that was paid, and they believed that it was for the previous period when it wasn't. It was actually the current period, the correct period, on time and appropriately paid. They were threatening a fine because they'd applied it incorrectly to the previous tax year that had already been paid. So I don't even know how that happened, but there we go. This is the time that we're living in. Let me know what you think in the comments below. Thank you for watching. Please do subscribe, and I'll see you in the next one.